What do you want?
Page number 14, number 48, page number 15, number 49.
Memo was filed by the petitioner seeking for withdrawal of the petition. Acceptance the number of petition dismissed as withdrawn.
48. 48. Page number 15, number 49 and 50. Page number 16, number 51 and 51, 53.
Yaar name of petition.
Page number 17, number 54. Page number 18, number 55. Page number 19, number 56 to 58.
The Lordships kindly, my lord, serial number 56, my lord, I appear for the response. We have informed the other side yesterday itself, please, my lord.
You just okay.
Please.
Number 21, number 59 to 61. Page number 22, number 62 to 65. Page number 23.
60. Application.
Page number 23, number 67 to 71. Page number 24, number 72 to 70. For things spoken to, page number 1 is the next report.
What is the mistake?
Both are two matters on the same lot. One matter is both the matter currently amount of paid, and one matter not interest was not paid. This matter not interest was also paid for. To make it matter, that's why not the order direct, not placed directed to pay.
In this case, both of them are paid.
Yes,
Therefore, interest was not necessary.
interest not.
You are again. Where is he?
That's like not paid,
Not paid.
not direct pay, not already. So other matter not what the in the shooting matter.
The interest is also paid in this case, no?
Yes, it is not paid. It's other matter not there. The absence and notice was issued. under execution was filed. In that matter, this petitioner was also party. There is a direction in the way of increment of the direction to pay 50% of the demanded amount. That is including the compound interest. You
Sure.
have to pay the 10% allowance in this compound interest also.
While disposing of the writ petition, it had been stated that for the belated payment, interest at 10% per annum was not paid. However, Learned Counsel failed the respondent points out that interest on the belated payment was also made. And therefore, the direction to pay interest on the gratuity amount was incorrect. In view of the statement of the Learned Counsel for the respondent, that interest on the belated payment was also paid. The direction issued in paragraph 4, paragraph 3 to pay interest on the gratuity amount is present.
Better.
Election, Anmund. Serviceman election.
Election.
Election. Election to
To the post of professor.
Andegagalva. ತಕ್ಷಣಕ್ಕೆ ಏನಾಗಲ್ವಲ್ಲ ದೊಡ್ಡ page is covered. Yeah. Is not in dispute that the issues raised in this writ petition are covered by the decision rendered by this court in the big number so also. In view of the said submissions, and in view of the above, this writ petition is also disposed of in terms of the order passed in the big number so also. ಏನಿದೆಯೋ ಟರ್ಮ್ಸ್ ಅದೇ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರು DJ to take notice for R1. Should be Arun to take notice for R2 to R4. ನೋಡಿದ್ರ ಅದನ್ನ ಮುಂದೆ ನಾನು DJ to take notice for respondents. Consider. Release stock. Give him a copy. Then a DJ to take notice for R1. Then survivor certificate and Rena.
Already approached the report and I have already got the succession certificate from the city report. Succession certificate from the procedural survivor certificate.
He's obtained a succession certificate itself. ಅದಕ್ಕಿಂತ ಬೇಕಾ ಆದ್ರೂ ಕೊಟ್ಟಿಲ್ವಾ Succession certificate is an order of the court. Then what is the next area?
Letter issued by
Who passed away? Your father, right?
No, director.
ತಂದೆ ತಾನೆ paternal uncle, the paternal uncle of the petitioners, then how will the paternal uncle of the petitioners passed away? And it appears that during his lifetime it executed a will. It is the case of the petitioners that they are the only legal heirs entitled to succeed to the estate of G. Krishnamurthy. It is also their case that they had filed a petition for grant of a succession certificate to the civil court, and in PNDC 170/2012, the civil court has granted them a succession certificate stating that they were entitled to receive the terminal benefits of the deceased G. Krishnamurthy. However, the third respondent has issued an endorsement. Fourth respondent has issued an endorsement stating that terminal benefits cannot be released since a survivor certificate has not been produced. In my view, this reasoning cannot be sustained in the light of the fact that the Competent Civil Court has granted a succession certificate in favor of the petitioners to the effect that they have succeeded to the estate of the deceased G. Krishnamurthy and are entitled to his terminal benefits. Therefore, the fourth respondent would have to necessarily abide by the succession certificate and release the terminal benefits to the petitioners. The same shall be done within a period of 1 month in the date of receipt of a copy of this certificate, starting with the AG of the day.
From 58 to 60. It's a government aided institution. That response. The government administration, this institution also is not accommodation.
What is annexure B?
Annexure B is our representation to follow the other institution. Then also we are going to. We made a recommendation. That's why we now the one.
All three notice, sir. Not AG to take notice for respondents 1 and 2. You're here, third respondent. Issue notice to R3. Without hearing them, how can I grant them? Our cable ಕೊಡ್ತೀನಿ ಅವ್ರು ಸರ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. Council is permitted to take out notice on the third respondent personally. Relist on Wednesday. Complete with the office objections.
That's I find the dispensation
It stated that an application for dispensation certificate copy is filed. Office to verify. ಯಾರಿಗೆ? Then AG to take notice for respondents. The prayer of this petition is for issuance of a mandamus to the second respondent to consider the representation stated 11/8/2022 and 18/10/2022. It is the case of the petitioners that he is due certain arrears of salary, and despite be giving a representation, the same has not been paid, arrears of salary and leave encashment. In my view, since the petitioner is requesting for payment of arrears of salary and also his leave encashment benefits, it would be necessary for the second respondent to consider the same and pass appropriate orders in accordance with law within a period of 2 months. In date of the second respondent shall also take into consideration the recommendation made by the third respondent for release of the terminal benefits in favor of the petitioner. 2 months. 2 months.
Shankar HS. On 8/2/2025, I furnished email. The public interest is not for the union, is not for public, industry, this transparency is the deed.
Yesterday, the president had said same.
As a matter of fact, that they want the petition to continue because there are various cases are pending. The auto against the previous directors and also those matters are being posted for evidence. And what
In ನೋಡಿದ್ದೀರಾ
here.
ಏನು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದು?
51 matter. Unless it is approval of the president, it can't be transferred.
ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕೊಳ್ತೀನಿ, ಕೇಳಿ ವಿಚಾರಿಸಿ. and AG to take notice for respond number. ಇಬ್ಬರು ತಗೊಳ್ತೀರಾ ನೀವೇ ಒಬ್ಬರಿಗೇನೆ? R1 should be Anand to take notice.
We are
For R2 released on Tuesday. Tuesday. What is annexure fee? What is annexure fee?
That is already directing us to appoint him as assistant librarian. Can you see the annexure A, page 27? He was appointed as a library assistant. There were a number of litigations where he said, my termination of the CBA. But in fact, there was an endorsement that was issued pending the annexure E. We sought for the department that the librarian post at that point of time. But grant was not sanctioned for that post. So we sought to the department to convert it to a permanent post. Two endorsements were issued about annexure C.
But what, where is the order of termination? That
There
is,
is no order of termination. What happened, the post became permanently, it was non-granted. Kindly the annexure E members, page 37. That was the endorsement
Page?
that was issued by the government, which is even today not challenged. Page 37, page 40, the relevant portion. At an earlier point of time, you had submitted a representative for informing of the college authority. At earlier exercise from 2004, page 40. Page 40.
yes.
At an earlier point of time, you have submitted a representation on 21/10/2005, informing that the college authorities had terminated the services from 2004 onwards. As such, requested this office to direct the college authorities to appoint him as a librarian. He was appointed not as a library assistant. It is a different thing altogether. You had submitted the representation on the ground that librarian post is vacant also. And also on the ground that you possess necessary qualification to hold the post of librarian post, which was vacant in your college, was treated as backlog post and was reserved for SC/ST. As such, your request was rejected on the 21/3/2006. Admittedly, you have been appointed as library assistant in 1993, and as per the above cited judgment, you will be entitled for recognition only on completion of tenure of service against a duly sanctioned post of library.
Now we'll assume that it was not admitted to a salary grade.
Yes.
If you appointed him,
2004 itself, it became permanently non-granted.
true, but still, once you appoint him,
Correct.
but once you appoint him, merely because you don't get an approval for a salary grade, that does not mean you can terminate him.
It is not a case that we terminated it. It's our case that he stopped coming because it became permanently non-granted. He was not interested. When the salary was meager, 250, 350. He did not want that. He wanted a granting post. So he made an application to the government, repeated application.
What is your defense for the EAT?
He said he has not been appointed. As in, because now what he did, he appointed him.
Page number 187.
187.
187.
That's the order. He did not want to continue that. That's exactly why I read that endorsement. He made an application to the.
What is your defense? I want to see your defense in the, give the tribunal.
Page 176 now. Respondent number 5, give a respondent. That's the college, the joint director of college education and things.
You not even said he has abandoned his work.
We have all these litigations, we have said that he did not come and sign the register from the court.
In paragraph page 176 and 177, there's no mention of such a condition being taken. Saying that he has abandoned his duties or
So
whatever.
this is where respondent number 5, that is the department. The joint director of college education. That is recorded.
Where's your objection? You have a copy of the objections.
If I'm right, they did not file any objection because this was remanded matter. So in the remand, they did not. Can I just read para 11, which sums up the entire case with.
No, this is only in relation to his approval of his appointment.
Because this was just a temporary can you see annexure B now? Annexure A was the name of Adisha, his appointment order. He is appointed on purely temporary basis as Sahaya Grantha Palakar. And that way we make a request to the department, annexure B, on 13/3/2003 itself, make it a permanent post. That is refused by annexure C and annexure E. All these endorsements remain unchallenged till today. But what happened in the meantime, one Mariswamy died, he was in library, his post became vacant. So he started saying, put me to that post, since he had obtained the additional qualification of Bachelor of Library Science during that time. So he made a representation to the college and to the respondents, saying, put me to the post of Mariswamy's librarian post. We said it cannot be done because you only granted a post at that point of time and we cannot directly appoint you to the Mariswamy's post. So he went on making representations to them.
No, that is another chapter. The order now is to reinstate him as an assistant librarian.
Library assistant, that's the problem with us. It's not assistant librarian, it's library assistant. He was not appointed as an assistant librarian. Kindly see me what's the next.
Take out notice, let us see, issue notice. Till the next date of hearing. The operation execution of annexure B should remain state.
There is no post of any of these three assistants.
But I don't see anything in your objection saying that he abandoned the work and therefore nothing of it.
At least the entire of the EHV.
And it is to take notice for respondents 1, 2, 3, na? 1, 2, 3. Who's R4? Who's R4?
R4. He's the person.
Number 10 is the name divided.
Okay.
Representation university considered being promotion. Very good. Who are not in the class. We was also.
OPS for respondents. Rajiv Gandhi.
Again.
Should TP Rajan Kumar to take notice. Issue notice. Council is permitted to take out notice on the Registrar General. We shall make arrangements for representation on behalf of the respondents.
Number 12. Will be able. Just one minute.
ಏನಾಯ್ತು ಪೆನ್ಷನ್?
ರಾತ್ರಿ 9:00ವರೆಗೆ ಹೋಗಿ ಬಂದಿದ್ದಾರೆ. ಯಾವ ಪೇಪರ್ಸ್ ಅಟೆಂಡ್ ಮಾಡಲಿಲ್ಲ. ಲಿಸ್ಟ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ಅವ್ರಿಗೆ ಏನೇನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕು ಅಂತ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾರೆ.
ಅವ್ರನ್ನ ಸಮಾಧಾನ ಮಾಡಿ ಅಂದ್ರೆ ನೀವು ಅವ್ರನ್ನ ಸಮಾಧಾನ ಮಾಡ್ತೀರಾ ನೀವು? ಇಲ್ಲ ಇಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರಾತ್ರಿ 9:00 ಗಂಟೆಗೆ ಎಕ್ಸಾಮ್.
ನಾಳೆಗೆ ಹಾಕೊಳ್ದು ಸೋಮವಾರಕ್ಕೆ ಹಾಕೊಳ್ತೀನಿ, ವೆರಿಫೈ ಮಾಡ್ರಿ ಏನೋ ಅದ ಕೊಟ್ಟಿದ್ದೀನಿ ಮಂಡೇ. ಅಲ್ಲ ಅದೇನೋ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇವತ್ತು ಮೊದಲು ಇದೇ ರೀತಿ ಕಾಣಿಸ್ತಾ ಇದೆ. ಅಲ್ಲೂ ಎಂಪ್ಲಾಯ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಇದು. ಅಲ್ಲಿ ಅಲ್ಲಿ ಸೇಮ್
ಆಯ್ತು ಸೋಮವಾರ ನೋಡು. ಇಲ್ಲ ಅವ್ರು ನೀವ್ ಹೋಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿಲ್ಲ, ಸುಮ್ನೆ ಹೋದ್ರಿ ಬಂದ್ರಿ ಕಾಫಿ ಕುಡ್ದಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ಅವ್ರು ಅದ್ ಬಿಟ್ರೆ ಏನ್ ಮಾಡಿಲ್ಲ ಅಂತ.
5 ಗಂಟೆವರೆಗೂ ಆಫೀಸ್ ಇರುತ್ತೆ. 8 ಗಂಟೆಗೆ ಹೋಗೋದು, 8:30 9 ಗಂಟೆಯಲ್ಲಿ ಕೊಡ್ಲೇಬೇಕು ಅಂತ ಇದ್ರೆ
on Monday I'll have it. By Monday, whatever they want, see that it is given. Don't go after 5 o'clock. Please go before 5 o'clock, and whatever is to be given, please give it and come. You are Hiremantrore. You heard his complaint. ಆಯ್ತು ಸೋಮವಾರ ಹಾಕೊಳ್ತೀನಿ. You are the Hiremantrore. You are the cause for all this. You started this. You invited this order unnecessarily. So you will have to bear this criticism. Somara, Ravindranath, don't carry it further. Please see that it is closed. Who appears for the second respondent?
Earlier, the honorable court has passed the order. One amount request.
No, who appears for the second respondent? AG to take notice for R1. Srimati Sumana Balaga to take notice for R2. Relist on Wednesday. ಏನಂತ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಅಂತ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಅಂತ
ಪ್ರಮೋಷನ್ ಆಗಿ ಕೇಸ್ ಆದ್ರೆ ಇವ್ರು ಇರೋಂಗಿಲ್ಲ ಅಂತ
next there is an order of posting pursuant to promotion and you are in charge
Post of revenue officer and office manager is equally post, carries equal pay.
but it's only an in charge element, isn't it? What is your right? If it's a regular posting, I'll accept, you should not be disturbed. If it's an in charge element, it is not a posting for which you have a specified tenure. How can you stick on to that post?
But there are vacant posts of revenue officer in the, there are many vacancies.
ಎಲ್ಲರೂ ಕೊಡಕ್ಕಾಗುತ್ತೆ ಅವ್ರಿಗೆ?
But I have the list.
And I'll permit to give a representation, you give a representation and ask him to consider within 2 weeks.
Well, there are 36 posts in the entire state. But mayor request is not. there is a post of revenue officer in government.
You know better than me how the system works. If I am given the power to post everybody, then
Direct them to post me anywhere.
that's why I said I'll ask you to give a representation and ask him to consider the same within a period of a week or two. That should solve the problem. It appears that you have taken on the money establishment, so they're not going to help you there. Alva,
Pending, they will accommodate, but it will become.
I will direct them. Why are you worried? The
You are-
petitioner, this will be more effective than he has expressed his inability to get you a posting. Or either instructions, agalla anta. That's why I will issue a direction. Take advantage of that. I cannot direct them to give you a posting, can I? As an in charge. As an in charge, kodaboda. Can ask him to post you in any in charge revenue officer posting.
But you posts are lying vacant.
That's why I'll make that observation. Take advantage of it. That is all.
Observe that, but Anikal and Sunaf are.
Don't push your luck too far. The petitioner is challenging an order of posting granted in favor of which respondent? Third respondent, pursuant to him being promoted. It is the case of the petitioner that he had been placed in charge and therefore should not be disturbed from the said position merely because third respondent is promoted and posted to that particular place.
And
Then council also submits. Then council also submits that the petitioner had been posted by the government and the said order of posting cannot be disturbed. He also submits that there are 36 additional posts which are available and the third respondent could be accommodated in any one of them. In my view, since the petitioner was only posted to be in charge of the post to which the third respondent is currently posted, the petitioner cannot have any legal right to insist that he be continued as an in charge arrangement. The challenge therefore to annexatory has no merit and the petition is therefore dismissed. However, since Learned Council submits that there are 36 other posts which are vacant, he is permitted to give a representation to the concerned authority to post him in any one of those 33 posts. If such a representation is given, the competent authority shall consider the same. And I am in regard to the fact that the petitioner was already working as an in charge revenue officer, consider his case sympathetically and pass appropriate orders. The petition is accordingly disposed.
2 weeks.
Anekal ಬೇಕು. ಅಲ್ಲ, challenge to annexatory is dismissed, WP disposed of. ಏನ್ ಪ್ರಶ್ನೆ ಮಾಡ್ತಾರ? ನಮ್ಮ ಕೋರ್ಟ್ ಬಂದ್ಬಿಟ್ಟಿದ್ರ ಏನ್ ಮಾಡ್ರಿ? ಇದು 3 ಸಲ ಬಂದಿತ್ತಲ್ಲ.
ಕನೆಕ್ಟೆಡ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ರೆ ಇಷ್ಟಂತ ತೋರಿಸಿ
ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರು. ಅಪೀಲ್ ಇದೆ. ಏನ್ ಮಾಡ್ಬೇಕೀಗ? Two weeks contract. The last occasion, the counsel who was appearing for the petitioner was permitted to retire. The name of the petitioner is shown in the cause list. There is no representation on our behalf. nor is any steps taken. Make a representative not clear. Left in order of the petition is dismissed, non-prosecution. In recalling, you know. Reasons stated in I-1/23, the order dated 17th of August 23 is recorded in the petition restored. After vacation. Vacation. Memo is fed checking for observer petition. The memo is accepted with petition dismissed as withdrawn. Same, 20 minutes.
21, 240. And very good. I request that the leading to be subject to law and then state the matter.
Madada after vacation madla. No, but if they are not ready, what do I do?
The applications appear and the file affidavit stating that the equal notification has been withdrawn and first notification has been not issued. That is so broad, sir.
I am not asking for an adjournment. I am ready. If all of you are ready, I am ready.
Our,
He does not want to go another month.
yeah, that's what
Vacation madla.
we did.
The list. What is the reason for them?
That is supposed to be document. But the contribution of the respondents are question. Because they take on in the year 2012. So they are, because they balance number of 2,000 which was deducted earlier. It was paid in the year 2017. So from 2012 to 2017, they have calculated the interest. But as per the applied Provident regulation rules of the corporation, is not entitled for interest as the amount.
What does the act say? Does the act not guarantee interest?
But you were demoted also, you were not important in terms of sign machine corporation. You were not important in terms of the corporation.
The total provident fund was 6,45,297. Correct? Do we admit that?
Yes, sir.
Out of which only 2,52,368 has been paid.
That's the price. The price,
What about the remaining?
same amount is. Corporation.
No, there was some endorsement that was given. So total amount is 3,92,913, including the interest component. Was that paid? Was that paid or not?
You are, employees contribution has been paid. If the employees contributions have been repaid, and that will be right. After retirement, which are depositing. With that, the climate operations.
What is this?
Regulation number 14.
Was it terminated
No, that is not.
in section?
Because suspended days to someone.
No, this underlining of this interest to cease on termination of service or death, interest and also some standing in the accounts of the fund to the credit of subscriber shall cease on the day on which he leaves the service of the corporation or on the day of his death, whichever is earlier. If you have not paid the amount, would you not suffer the liability of an interest?
It was deducted after the react.
No, this was your contribution, isn't it? So if you do not contribute to the account, and if there's a delay, who's to bear the burden of interest? If somebody has to pay the corporation money, and if they don't pay, will you accept the money without any interest after 6 years? Then the same principle should apply, isn't it?
Commission for capital deducted from the price.
No, that you are bound to pay that. That is not your money. He had contributed, you gave it back to him.
With interest not paid.
Law declares that you should also pay equally. If that is not paid within the time prescribed, then what is the consequence?
Since section says that it is deducted after the retirement. That confusion is.
Whose fault is it? Deduction after whose fault is it? Who's is he at fault?
He was demoted due to.
Is he at fault, Mr. Managing Director? Then when was the money due to him? So for 11 years, pay him interest and close the matter. That is all.
Interest will date of retirement.
From that date, pay interest on this 2 lakh. 2,52,368.
Produce the documents from 1923, but they themselves are running endorsement through RTA that I'm entitled for 4,22,103.
ಎಲ್ಲಿದೆ?
On 1923, I was used for the large. Open for that.
4,22,103.
Number 91.
Yes, 4,51,013.
Yes, ma'am. They themselves are provided to RTA.
2,52,000 plus calculation. 2,52,000 calculation. This was deducted after his retirement. Yes, it is there in the PF account. As per this section 2E of the PF Act, since it has been deducted after the contributed calculation is conducted after retirement. Previous statement.
The mistake is yours, isn't it? Mistake is yours, isn't it? So you'll have to pay interest on that amount.
Interest.
What is the prescribed interest?
Then the amount of 4,22,103. The target.
ಯಾವತ್ತು ಕೊಡ್ತೀರಾ ಅದು? ಯಾವತ್ತು ಕೊಡ್ತೀರಾ?
Regarding paying calculation. Interest has to be paid with whichever amount is interest rate. Whatever interest of the enterprise contribution that will be paid. Regarding contributions of the calculations, which have been paid after that there is some ambiguity that we need some clarification.
What is the ambiguity that you have?
That the deposited after the return. That is to be deposited has happened from the calculation equal to the calculation. So whether that since it has been deposited after the retirement, whether it is able to get that amount.
Then what was the point of you contributing? No, the very purpose of your contribution is to see that he gets the money, isn't it? It's a matching contribution, isn't it? You should have given it before he retired, correct? If you have not done it, you will are bound to pay interest.
He was demoted. This is the differential contribution that has been done. He was demoted and he was paid, yes, sir. He was demoted on August 2023. That was not paid actually. Inquiry was also conducted.
So for 9 years, your contribution is a lower amount,
Yes.
though he has contributed a higher amount.
As I submitted in the last year, it is spoken for month, then they will start with the 2,28,750. Out of this, we have already paid total than that, 36,338. By deducting this contribution, 2,52,388 paid immediately. This amount also we have paid in the year 2017 on 6th May 2017. We have repaid 2,52,300.
That was his contribution. What about your contribution? That you are bound to pay, isn't it? Is there escape from that contribution?
Contribution made after contribution has also been made after it. So now, the act section says after the retirement interest now.
Which act? This regulations. PF Act LLA. You're referring to this regulation, isn't it? This is your regulation. The act will prevail, isn't it? The Employee Provident Fund Act. Not your regulation. When will you pay? Pursuant to the order dated 8/12/2023, the Deputy General Manager Finance as well as the Managing Director of the Karnataka State Warehousing Corporation are present. It is their contention that the sum of rupees 2,50,368 was deducted as that was the petitioner's contribution towards Provident Fund. And the same was also paid in the year 2017. They state that the employer's contribution, that is the contribution, the equal contribution to be made by the warehousing corporation was made after the petitioner attained the age of superannuation. And as per their regulations, the interest on that would cease to be paid. In other words, it is their case that since the contribution is to be made after the petitioner attained the age of superannuation, there is no liability on their part to pay the interest. Correct? In my view, since it was the primary duty of the corporation to contribute the Provident Fund while the petitioner was in service, the subsequent payment will not absolve the corporation of its liability to pay interest. The purpose of contributing equally is to ensure that the employee gets the Provident Fund at the time of his retirement. And assuming there's a delay in contribution of the employer due to any reason whatsoever, the liability to pay the interest on that would not cease. In that view of the matter, the corporation is directed to pay the sum of rupees 4,51,013 as indicated. This is up 2019. As of now, it's 4 lakh so and so, which is stated to be due
4,84,000.
as on today, which would be inclusive of the interest component. The said amount shall be paid on or before 31st, on or before 5th of January 2024. The writ petition is accordingly disposed of. However, post this matter on the 6th of January to report complaints. It will be released on 6th, on which date you have to report complaints? 8 January.
One corporation not has filed the objection, except denial and not the. Here, the not objection, but case in that not.
Then rectification of Office objections and idea. External objections has been served on the petitioner's counsel, hence the office objections stand completely.
The petitioners, they will a simple.
They are ready. Ready.
Now, all the petitioners, when, have been appointed as complainant.
What is the next R?
Next, all the seniority list, which they have, next, all the decision they have taken for filling up the post, the publication of the final list.
Oh, dear.
ಬೇರೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ದಿನಾಂಕ 1/28/2019 ಸಹಾಯಕರ ಸಹಾಯಕ ತಾತ್ಕಾಲಿಕ ದೇಶದ ಪಟ್ಟಿಯಲ್ಲಿ ಉಲ್ಲೇಖವಾದಂತೆ 22/5/2020 ಹೊರಡಿಸಿದ 15 ದಿನಗಳ ಕಾಲಾವಕಾಶ ನೀಡಿ ಆಕ್ಷೇಪಗಳನ್ನು ಆಹ್ವಾನಿಸಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಹಲವಾರು ಸಿಬ್ಬಂದಿಗಳು ತಾತ್ಕಾಲಿಕ ಸೇವಾ ದೇಶದ ಪಟ್ಟಿಗೆ ಆಕ್ಷೇಪಗಳನ್ನು ಸಲ್ಲಿಸಿದ್ರು. ಆಕ್ಷೇಪಗಳ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೆಸಲು ಹಾಗೂ ಈ ಬಗ್ಗೆ ತೀರ್ಮಾನಗಳಲ್ಲಿ ಉಲ್ಲೇಖ 2/15/2020 ವಿಶೇಷ ಆಯುಕ್ತರು ಅವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿದ ಸಿಬ್ಬಂದಿಗಳೊಂದಿಗೆ ಸಭೆಯನ್ನು ಹಮ್ಮಿಕೊಳ್ಳಲಾಗಿರುತ್ತದೆ. ಸಭೆಯಲ್ಲಿ ಆಕ್ಷೇಪಣೆ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೆಸಿ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲನೆ ಮಾಡಿ ತೀರ್ಮಾನ ಕೈಗೊಂಡು ಆಕ್ಷೇಪಣೆಯನ್ನು ವಿಲೇವಾರಿ ಮಾಡಲಾಗದಂತೆ 1/1/2020 ಸಹಾಯಕ ಅಂತಿಮಾದೇಶದ ಪಟ್ಟಿಯನ್ನು ಸಹಿ ಮಾಡಿ ಇದರೊಂದಿಗೆ
You have challenged the final seniority list.
My case is that we have been appointed on compassionate grounds. Our date of appointments cannot one and is shown correctly. Only difficulty is till 2019. Annexure date may get missing. Annexure date in which cannot for the first time in 2020 we have been appointed from 2010 to 2014. For the first time, annexure date page 301. I have mentioned in the 20 draft list, we have been brought down by 139, 139, 144 below, seniority list below. This is on the basis of the excess quota, which they have given to others. That is persons who have.
But if I remember correctly, in that petition, that the argument was that your appointments are earmarked to the DR quota.
DR quota. DR quota is correctly mentioned. There is no difficulty. Only thing is that while now have 15 to 19 they have prepared a proper seniority list, they have been given proper ranking. In 20 for the first time they bring it down nearly about 150 posts below. The persons on the ground according to on the ground that the persons who have been promoted in the cadre of personal assistant, they have been excessively promoted, which they themselves indicate in their seniority.
No, what is to which quota are you allocating them? DR quota or promoting quota?
Here.
Then how can you push them down if they have been appointed within the quota prescribed for the DRs?
Yes.
In that case, if the quota of promotees is exceeded and larger number of promotees are promoted, then you can push them down. But if they are promoted against a recruited against a DR quota, how can you push them down in seniority?
That's all.
ನೀವು ಹೇಳ್ಬೇಕು ಒಂದು ಸ್ಟ್ಯಾಂಡ್ ತಗೋಬೇಕು ನೀವು ಹೆಂಗೆ ಅನ್ನುವಂತ. You want to secure instructions because if I say that, then it amounts to admission. You simply have to make a statement as to whether they belong to the DR quota or to the promotees quota. If they are in the DR quota, what is the reason for you to push them down? That is all.
They have considered under DR quota. They cannot consider me under professional quota because we are.
ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ ಇರ್ರಿ. Why did they push them down? ಕೇಳ್ಕೊಂಡು ಹೇಳಿ. Wherever you push down, let us find out.
Written arguments,
Wednesday. Oh, he has to make a submission Wednesday. There are three yaru. ಯಾರು ಅಪಿಯರ್ ಆಗಿದಾರಲ್ವಾ? ನೋಡಿ ಬೇರೆಯವ್ರಿಗೆ ಅಪಿಯರ್ ಆಗಲ್ವಾ ನೀವು? ಎಸ್ಕಾಂಗೆ ಯಾರು? Rakshitana. So the Rakshitana will take notice for R3. Objections hakidara? Objections if any in 2 weeks.
26, Yarkisham Shikraya. Number 26.
Serious allegation against the Provident, not the management. The issue nature of issue of washing the appeal number. That one number 150 below. Appeal number 11 number 25 issue direction directly respond number 2 consider the application.
ಎಲ್ಲೋ ಓದ್ತಿದ್ದೀರಾ ಎಲ್ಲೋ ಓದ್ತಾ ಇದ್ದೀರಾ
Page number 11 25,000.
WP
25,000.
page number 11 is prayer kora.
The appeal was rejected by the second response. Again, the subsequent prayer may not issue the election direct response to consider the application. ADP later, also with the petition of the respond number 7. The institution as per the sexual allegation is respond number 1. The serious allegation against the respond number 2. And the don't tell page number page number 7.
The category 2A.
2A.
Category 2A.
2A. How I appointed as per page number 29. Number 30.
They have to set a proposal. It was not submitted. It was not submitted. They have set a proposal. They have not set it.
Right, and the point ಬರ್ತೀನಿ ಆರ್ಬಿಟ್ರೇಟ್ ಮ್ಯಾಟರ್ serious allegation against the government drugs. The ground payment page number 70 maintained is that is to be noted permission granted by the respondent below report of teacher under general category according to respondent number 4. They have followed the proposal to appointment of the petitioner as a appointed teacher. Which has followed the same as the recommendation. Respondent number 2. On the basis of report submitted to concerned authority, recommending the approval of court of petitioner. But since from 2015, mechanism is kept pending before the government. Under various stage file has been proceeded, ultimately the file is within respondent number 2 is approved. I will send the proposal. The response to 2 is not a.
I asked you after 9/5/2018.
Serious allegation that I have sent the proposal to the appointment of the petitioner in page number F, page number 24. The commissioner, the director had issued a letter to me. Page number 24, unanswered.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಿದ ಅರ್ಜುನ್ ಕುಮಾರ್ ಪುರಶಾಲೆ ಶ್ರೀಯವರು ಬೆಂಗಳೂರು ಈ ಶಾಲೆಯಲ್ಲಿ ಶಾಲೆಯ ಶಿಕ್ಷಕರು ಒಟ್ಟಿಗೆ ದೇವಾಲಯದಲ್ಲಿ ನೇಮಕ ಮಾಡಿಕೊಂಡು ಪದವಿ ನೇಮಕ ಅನುಮತಿಸುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ಒಂದರಲ್ಲಿ ನೀವು ಸಲ್ಲಿಸಿದ ಪ್ರಸ್ತಾವನೆ ಪರಿಶೀಲಿಸಿದಾಗ ಈ ಕೆಳಗಂಡಂತೆ ನಿಯೋಜನೆಗಳು ಅವರು ಸರಿಪಡಿಸಿಕೊಂಡು ಮರುಪರಿಶೀಲಿಸಿ ವಾಟ್ ಈ ಡಿಫೆಕ್ಟ್ ಎಂದರೆ ಹುದ್ದೆಗೆ ಪ್ರಕಟಣೆ ನೀಡಿರುವುದು ಗಮನಿಸಿದಾಗ ಸ್ಪಷ್ಟವಾಗಿ ಪ್ರಕಟಣೆ ನೀಡಿರುವುದು ರಾಜ್ಯಾಂಗ ಪ್ರಕಟಣೆಗಳ ಜೊತೆಗೆ ರಾಜ್ಯಾಂಗ ಪ್ರಕಟಣೆಗಳ ಪುಟದಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ಗೋಚರಿಸುವಂತೆ ಪ್ರಕಟಣೆ ನೀಡಲಾದ ಕಾರಣ ಅನುಮತಿಯ ಬಿಂದುಗಳ ಅಭ್ಯರ್ಥಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಸುಲಭವಾಗಿರುತ್ತದೆ. ಮತ್ತೊಮ್ಮೆ ಮೇಲ್ಕಂಡ ಪ್ರತ್ಯೇಕ ಪ್ರಕಟಣೆ ನೀಡಿ ಅನುಮತಿಸಿದ ಬಿಂದುವಿನ ಅಭ್ಯರ್ಥಿಯನ್ನು ಅರ್ಜಿಯನ್ನು ಪಡೆದು ಕ್ರಮ ವಹಿಸಲು ತಿಳಿಸಿದೆ. ಉದ್ಯೋಗ ಕೊಟ್ಟು ಅಭ್ಯರ್ಥಿಯ ವಿದ್ಯಾರ್ಥಿ ಪ್ರಮಾಣ ಪತ್ರ ತಿಳಿಸಿದೆ. ಈ ಸಂಬಂಧ ಮತ್ತೊಮ್ಮೆ ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರ ರೂಲ್ಸ್ means 2A is bindu. The appointed is 2A. That letter was issued me on 4/17. ನಿಯಮಾನುಸಾರ ಪ್ರಸ್ತಾವಿಸಲು ತಿಳಿಸುತ್ತಾ ಕೂಡ ಪ್ರಸ್ತಾವನೆ ಹಿಂದಿರುಗಿಸಿದೆ. Thereafter again another letter was issued by the management. Page number 39. page number 13 and letter P. On
No,
6/4/2018.
this particular order was
That are not to join any petition.
4/5/2017. Pursuant to this, when did you send the proposal?
I have proposed training this ನಿಮ್ಮ ಪತ್ರದ ಸಂಖ್ಯೆ ಇದೆ 14/17 ಅಲ್ಲಿ ಕಳಿಸಿದ್ದು.
ಕರೆಕ್ಟ್. ಅದಾದ್ಮೇಲೆ
ಆಮೇಲೆ ನಾನು ಕೊಟ್ಟಿದ್ದೆ.
ಈ ಸಂಬಂಧ ಮತ್ತೊಮ್ಮೆ ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲು ತಿಳಿಸುತ್ತಾ ಪೂರ್ಣ ಪ್ರಸ್ತಾವನೆ ಹಿಂದಿರುಗಿಸಿದೆ. So after 4/5/2017, you did not send a proposal.
What I will do, ಮತ್ತೆ again transfer ಮಾಡಿ paper notification ಕೊಟ್ಟು is
Then what is Annexure H, page 26? Annexure H ಓದಿ. We'll go date wise. Why should we jump?
ಬೇರೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಖಾಲಿ ಇರುವ
Annexure H, page 26. Annexure H, page 26, dated 15/12/17.
15%. Considering that the other places pertaining to police ತಾವು ಕುರಿತಿರುವ ಇಂಟ್ರಾಸಿದ್ರೆ
So this was one more letter that you sent. ತಮ್ಮ ಸಂಸ್ಥೆಯಿಂದ ಅಧಿಸೂಚಿಸಲ್ಪಟ್ಟ ದಿನಾಂಕ 11/11/2017. ನೋಡಿ, ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ
11/11/17 ರಾಜ್ಯದ ಉದ್ಯೋಗ ಇಲಾಖೆ ಕಚೇರಿಯಲ್ಲಿ ಅನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಪರಿಶೀಲಿಸಿದ 16 ಪತ್ರದ ಮುಂದೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್
ಓದಿ. ಅದನ್ನ ಓದ್ಲಿಲ್ಲ ನೀವು, ಅದನ್ನ ಲೆಟರ್ ಓದಿ.
ತಾವು ಸೂಚಿಸಿರುವ ಮೀಸಲಾತಿಯನ್ನು
ಅಲ್ಲ, ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ತಮ್ಮ ಸಂಸ್ಥೆಯಲ್ಲಿ ಖಾಲಿ ಇರುವ CBZ
ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಿಸಿ ಈ ಕಚೇರಿಯಲ್ಲಿ ಮುಂದಾಗಿರುವ ಅಭ್ಯರ್ಥಿ
So you requested them to accept this particular person. Next, ತಾವು ಸೂಚಿಸಿರುವ
ಮೀಸಲಾತಿ ನಿರ್ಣಯಿತ ವಿದ್ಯಾರ್ಥಿ ಒಂದು ಅಭ್ಯರ್ಥಿಗಳು ಲಭ್ಯ ಇರುವುದಿಲ್ಲ. ಆಲೋಚನೆ ಅಭಿಯೋಗವನ್ನು ಕೋರಿ ರಾಜ್ಯದ ಎಲ್ಲಾ ಉದ್ಯೋಗ ಪ್ರಕ್ರಿಯೆ
Next, what happened afterwards? Yes, please read Annexure H.
Before that one,
We'll go date wise. Why are you jumping?
Page number 38, the annexure P. 6/4/18.
Yes.
You directly issue letter to the exterior. ಅವಶ್ಯ ಪೊಲೀಸರಲ್ಲಿ ಖಾಲಿ ಇರುವ ನೇಮಕಾತಿ ಅನುಮೋದನೆ ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀ ವಿದ್ಯಾಸಂಸ್ಥೆ ಬೆಂಗಳೂರು ವಿಕೃತಿ ನಡೆಸುತ್ತಿರುವ ಅರಸಕುಮಾರ್ ಪೊಲೀಸ್ ಕಾಲೇಜಿನಿಂದ ಇಲ್ಲಿ ಖಾಲಿ ಇರುವ ವಿಜ್ಞಾನ ಶಿಕ್ಷಕ ಹುದ್ದೆ ಅನುಮತಿ ಪಡೆದಿದ್ದು, ಈ ಹುದ್ದೆಗೆ ದೇವರಾಜ ಎಂಬ ಅಭ್ಯರ್ಥಿಯನ್ನು ನೇಮಕ ಮಾಡಿಕೊಂಡಿದ್ದು, ಅನುದಾನಕ್ಕೆ ಒಳಗಿರುವ ಸರ್ಕಾರಕ್ಕೆ ಮನವಿ ಮಾಡಿರುತ್ತಾರೆ. ಸರ್ಕಾರ ಈ ದೇವರಾಜ ಅವರ ಪ್ರಸ್ತಾವನೆ ಅಗತ್ಯದಾರರನ್ನು ಸಲ್ಲಿಸುವಂತೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಸರ್ಕಾರದ ನಿರ್ದೇಶನದಂತೆ ನೇಮಕಾತಿ ಪ್ರಸ್ತಾವನೆಯು ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ದಾಖಲೆಗಳನ್ನು ಜರೂರು ಸಲ್ಲಿಸಲು ತಿಳಿಸಿದೆ.
So this was a second direction issued in regard to Devraj. Devraj is a petitioner.
Petition as per rules ಪ್ರಕಾರ ಮತ್ತೆ again call for the ಅಲ್ಲ ಇದೆ
Earlier,
ಕೋರ್ಸ್ ಅಲ್ಲಿ
ಅಲ್ಲ, earlier paragraph ಏನಾಯ್ತು ಹಂಗಾರೆ? ಅದು ಇದು ಇಗ್ನೋರ್ ಮಾಡಬೇಕು ಅಂತಾನೆ ಈ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಅದೇ because of
ಸೊ ಹಂಗಾರೆ ನಿಮ್ಗೆ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬೇಕೋ ಅದು ಚೂಸ್ ಮಾಡ್ಕೊಳ್ತೀರಿ, ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬಿಟ್ಬಿಡ್ತೀರಿ.
government is misleading of the
No, government is clear. It says
government has to take necessary.
government is categorically said ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ಅನುಮತಿ ಪಡೆದಿದ್ದು, ಈ ಹುದ್ದೆಗೆ ಶ್ರೀ ದೇವರಾಜ್ ಎಂಬ ಅಭ್ಯರ್ಥಿಯನ್ನು ನೇಮ ಮಾಡಿಕೊಂಡಿದ್ದು, ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿರುವಂತೆ ಸರ್ಕಾರಕ್ಕೆ ಮನವಿಯನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ಆಮೇಲೆ ಸರ್ಕಾರ ಶ್ರೀ ದೇವರಾಜ್ ಇವರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಅಗತ್ಯ ದಾಖಲೆಗಳೊಂದಿಗೆ ಸಲ್ಲಿಸುವಂತೆ ತಿಳಿಸಿರುತ್ತಾರೆ. So the direction was to submit a proposal in respect of Devraj, not to conduct a fresh process of selection.
ಅದು 4/5 ನಾನು
ಇದೇನು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಲೆಟರ್ ಇಗ್ನೋರ್ ಮಾಡ್ತೀರಾ, ಯಾವ್ದು ಮಾಡ್ತೀರಾ?
4/5 important.
ಇದು ಇಂಪಾರ್ಟೆಂಟ್ ಅಲ್ಲ.
ಅಂದ್ರೆ ನನಗೆ ಯಾಕೆಂದ್ರೆ ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ರೆ ನಾವು ಪ್ರಪೋಸಲ್ ಕಳ್ತೇವೆ.
ಯು ಆರ್ ಡೂಯಿಂಗ್ ದಿಸ್ ಆನ್ ಪರ್ಪಸ್.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಆಯ್ತು ಅದರಲ್ಲಿ ಇದರಲ್ಲಿ 9/18 ನಲ್ಲಿ 9/18 ನಮ್ದೇನಿಲ್ಲ ಗೌರ್ಮೆಂಟ್ ಅಪ್ರೂವ್ ಮಾಡಿ ನಾವು ಪ್ರಾರಂಭಿಸಲಿಲ್ಲ
ತಗೊಳ್ತಿಲ್ವಲ್ಲ ನೀವು, ಕಳ್ಸೇ ಇಲ್ವಲ್ಲ ಪ್ರಪೋಸಲ್.
ಅಪ್ರೂವ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ನೀವು
ಅಪ್ರೂವ್ ಮಾಡಿದ್ರೆ
pursuant to 9/5/2018, where is the proposal sent by you?
sent by is not this would pretty be okay.
It is not. You are forcing me to impose exemplary cost.
ಇದರಲ್ಲಿ ಏನು ಅನಿಸಿಕೆ ಕೇಳಿಲ್ಲ.
You come back to annexure this J page 29.
ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 28
ಇದ್ರಲ್ಲಿ ನೋಡ್ರಿ ಉಲ್ಲೇಖ 6/4/2018 ರೆಫರೆನ್ಸ್ ಇದೆ
ಅಲ್ಲ 6/4/18
ಆಯ್ತಾ. ಈ 6/4/2018 ಗೆ ತಮ್ಮ ಸಂಸ್ಥೆ ಉತ್ತರ
4/17 ರೆಫರೆನ್ಸ್
ನಾನು ಹೇಳಿದ್ದಕ್ಕೆ ನೀವು
ಅಲ್ಲ ನನಗೆ ಅದು ಇಂಪಾರ್ಟೆಂಟ್ 4/17 is important.
all right, then I'll pass what is important to me. If this is your
By misunderstanding
no, you are doing it deliberately.
deliberately even till today I will take
Please come back to annexure J. They referred to this letter dated 6/4/2018 and kindly refer ನಿಮ್ಮ ಪತ್ರ ದಿನಾಂಕ 24/4/2018. Now please please read the entire letter.
ಈ ಸಾಮಾನ್ಯ ಉದ್ದೇಶದಿಂದ ಈ ಅಗತ್ಯ ಮುಗಿಯುವುದಿಲ್ಲ. ನಡೆಯುತ್ತಿರುವ ರಾಜಕುಮಾರ್ ಪ್ರೌಢಶಾಲೆ ಈ ಪ್ರೌಢಶಾಲೆಯಲ್ಲಿ ಖಾಲಿ ಇರುವ ಮೀಸಲಾತಿ ಬಿದ್ದು ಇದರಲ್ಲಿ ಭರ್ತಿ ಮಾಡಿಕೊಂಡು ಲೇಖ ಅನುಮತಿ ನೀಡಲಾಗಿದೆ. ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿ ವಲಯದಲ್ಲಿ ಖಾಲಿ ಇರುವ ಮೀಸಲಾತಿ ಬಿದ್ದು 2 ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು 3 ಬಾರಿ ಪ್ರಕಟಣೆಯನ್ನು ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯನ್ನು ಪ್ರಕಟಿಸಿದ ಅರ್ಜಿಯನ್ನು ಆಹ್ವಾನಿಸಲಾಗಿತ್ತು. ಯಾವುದೇ ಕೂಲಿಯ ಅಭ್ಯರ್ಥಿಯು ಅರ್ಜಿ ಸಲ್ಲಿಸದೇ ಇರುವ ಕಾರಣ ಸಲ್ಲಿಸಿದ ಅಭ್ಯರ್ಥಿಗಳು ಶಾಲಾ ಸಂಸ್ಥೆ ಸಾಮಾನ್ಯ ವರ್ಗದ ಅಭ್ಯರ್ಥಿ ಅವರನ್ನು ದೇವಾಲಯ ಅವರನ್ನು ಸಹ 24/14 ಸಂದರ್ಶನ ನಡೆಸಿ 25 ಮಾಡಿದ್ದು ದೇವಾಲಯ ಅಭ್ಯರ್ಥಿ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಹೊಂದಿದೆ ಅನುದಾನ ಸಹಿತ ಅನುಮೋದಿಸಲು ಕ್ರಮವಹಿಸಲಾಗಿದೆ. ದಿನಾಂಕ 23/3/2017 ಜಿಲ್ಲಾ ಸದಸ್ಯ ಪರಿಷತ್ ಸಮಿತಿ ಸಮಿತಿ ನಿರ್ಣಯದಂತೆ ದೇವಾಲಯ ಇವರ ನೇಮಕಾತಿಯನ್ನು ಅನುಮೋದಿಸಿ ವೇತನವನ್ನು ಒಳಪಡಿಸಲು ಅನುದಾನ ಸಹಿತ ಶಿಫಾರಸು ಮಾಡಿ ಪ್ರಸ್ತಾವನೆ ಮಾನ್ಯ ಆಯುಕ್ತರ ಪ್ರತ್ಯೇಕ ಇವರಿಗೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಸದರಿ ಅಭ್ಯರ್ಥಿಯನ್ನು ನೇಮಕಾತಿ ರದ್ದುಪಡಿಸಿದ್ದೇವೆ ಎಂದು ತಿಳಿಸಿ ಮತ್ತೊಮ್ಮೆ ಪ್ರಕಟಣೆ ನೀಡಿ ಪ್ರಸ್ತಾವನೆ.
So after 6/4/2018, when the direction was issued to you to submit a proposal of Devraj, you replied by saying you have cancelled his appointment. ನೀವೇನು ಹೇಳ್ಕೊಳ್ಳಿ. That was your response, saying that you have cancelled his appointment, therefore you will not send the proposal. ನಾನು ಬಿಡಿ ಹಂಗಾರೆ ನಾನೇ ಮಾಡ್ಕೊಳ್ತೀನಿ ನೋಡ್ರಿ. ಇಲ್ಲ, ನಾನು ನಿಮ್ಮ ಮೇಲೆ ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ ಬರೀ ಪ್ರಪೋಸಲ್. I will explain in my order. I will, since you are not been
approve ಮಾಡಿಲ್ಲ ಅಂತ ನಾನು ಸ್ಯಾಲರಿ ಕೊಡಬೇಕಾಗ್ತದೆ. is not approved. Why salary was paid in management? His appointment order is accepted. We study this appointment order. Please note this. ಶಿಕ್ಷಣ ಹುದ್ದೆಯ ಉಲ್ಲೇಖ ಒಂದರಲ್ಲಿ ಬೆಂಗಳೂರು ಆದೇಶದಂತೆ ಶಿಕ್ಷಣ ಹುದ್ದೆ ಭರ್ತಿಗೆ ಅನುಮತಿ ನೀಡಿದ್ದು ಉಲ್ಲೇಖ 2 ಕಚೇರಿ ಪತ್ರದಲ್ಲಿ ಸಂದರ್ಶನ ನಡೆಸಲಾಗಿದೆ. ದೇವಾಲಯ ಅವರನ್ನು ವಿಜ್ಞಾನ ಐಚ್ಛಿಕ ಹುದ್ದೆಗೆ
ಬಿಡಿ, ನಾನು ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ, ನೀವು ಆನ್ಸರ್ ಮಾಡಲ್ಲ. ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ, ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ. I will explain in my order as to why.
Government approve ಮಾಡಿದ್ರೆ ಅವತ್ತು ಕಾಣ್ತಾ ಇದೆ. It's not my mistake. ಒಂದ್ಸರಿ ರಿಜೆಕ್ಟ್ ಆಗುವಂತಂದ್ರೆ ರಿಜೆಕ್ಟ್ ಆಗುವಂದ್ರೆ ನಾನು ಮತ್ತೆ ಪತ್ರಿಕೆ ಪಬ್ಲಿಷ್ ಮಾಡಿ ನಾನು ಅಪಾಯಿಂಟ್ ಮಾಡಿ.
From 2018 you have ensured that his appointment was not approved, therefore you denied him the salary. So I will hold that you are responsible for that salary difference.
ಈ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಬಿಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇದು ಅಡ್ಮಿಟೆಡ್ ಇನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್.
ಬನ್ನಿ. The respondent institution
Input generation not allowed.
ಇವಾಗ ನೀವು ಬಂದ್ಬಿಟ್ಟಿದ್ರೆ ಅವಾಗ
ಅದೇ input generation.
seventh respondent institution secured the permission of the department for filling up the post of CBZ lecturer ಆಯ್ತು ಇಲ್ಲ assistant teacher. The post of assistant teacher in CBZ. This post was reserved for a candidate belonging to category 2A. Pursuant to the said permission, though the institution issued paper publications and sought to recruit a candidate belonging to category 2A on 3 occasions, the college was unable to secure a candidate belonging to category 2A. Consequently, the institution proceeded to appoint the petitioner on 24/10/2016. The seventh respondent thereafter proceeded to seek for approval of the said appointment. But by communication dated 4/5/2017, the department took certain objections and directed the college to submit a fresh proposal. Right, the next ref. Thereafter, the petitioner appears to have approached the government requesting the intervention of the government in the matter of granting approval. Yadu the next sir? 6/4. Page. La order thos. Thereafter, the government the government acted upon the said request and directed the director to submit a proposal for approving the appointment of the petitioner herein. The director in turn, by his letter dated 6th of April 2018, called upon the deputy director to submit a proposal in favor of the petitioner. The terms of the said letter, the contents of the letter reads as follows. The institution which had appointed the petitioner, however, sought to raise a contention by its letter dated 24/4/2018 that it had cancelled the appointment of the petitioner and had decided to issue a fresh paper publication. In response to the said letter, the deputy director addressed a letter dated 9/5/2018, which reads as follows. E paragraph underline last but not least. As could be seen from the underlined paragraph, the contention of the institution that it had cancelled the appointment of the petitioner and it would undertake a fresh process of recruitment was negatived by the department. And it was categorically stated that such a course of action was impermissible. Though the government directed the seventh respondent institution to submit a fresh proposal, the seventh respondent has not submitted a proposal at all. On the other hand, the seventh respondent has proceeded to issue a fresh paper publication and has made an attempt to appoint and has attempted to appoint another person in place of the petitioner. Consequently, the petitioner filed WP. Then a secondary petition, WP 22292 of 2019, which is tagged along with this writ petition. the petitioner being aggrieved by the inaction of the seventh respondent institution preferred initiate a proceeding under section 133 of the Education Act. The authority, after hearing the parties, has proceeded to pass an order in the following terms. Page 113. The competent authority, instead of noticing that the government had directed the institution to send a proposal to approve the appointment of the petitioner, and though the department officials had called upon the institution to submit a proposal in that regard, has nevertheless proceeded to pass an order which has not decided any issue at all. In my view, in the light of the clear stand of the government that the cancellation of the appointment of the petitioner and a fresh process of recruitment to be undertaken was impermissible, the authority was bound to issue a direction to the seventh respondent institution to comply with the orders of the deputy director and submit a proposal for appointment of the petitioner. Next, however, from the stand taken by the institution, it appears that an attempt is being made to deny the petitioner in securing an approval to his appointment. This conduct of the seventh respondent institution is condemnable, to say the least. Once the authority which would bear the burden of the petitioner's salary themselves stated that the proposal of the petitioner was required to be submitted, the seventh respondent institution, by refusing to act upon this letter, has attempted to defy the direction of the government. In my view, in the light of the clear direction in the communication 9/5/2018 to the respondent to submit a proposal, the seventh respondent was bound to submit a proposal. It is to be noticed here that the seventh respondent did not challenge the stand taken by the department that it could not have cancelled the appointment of the petitioner and was bound to submit the proposal. The seventh respondent, having accepted this letter dated 9/5/2018, was duty bound to submit the proposal of the petitioner. So in this view of the matter, the seventh respondent is directed to forthwith submit a proposal regarding the approval of the appointment of the petitioner, and on such proposal being received, the government shall pass appropriate orders approving the appointment of the petitioner. In my view, since the seventh respondent is responsible for the delay in the appointment of the petitioner, it would be appropriate to settle to the cost of 1 lakh. Yes, madam. Come here. When he's saying 1 lakh is too less, cost of rupees 50,000 payable to the petitioner within a period of 2 weeks. ನೀವು ಪ್ರಪೋಸಲ್ ಕಳಿಸ್ಬಿಟ್ಟು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನಾನು ವೇ ಮಾಡ್ತೀನಿ. ನೀವು ಪ್ರಪೋಸಲ್ ಕಳಿಸಿ ತಕ್ಷಣ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕಳಿಸ್ಬಿಟ್ಟು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನಾನು ಐಲ್ ರೀಕಾಲ್ ದಿ ಆರ್ಡರ್. In view of the order passed in this debt petition, no orders would be necessary and WP 222/2019. Connect ಮಾಡ್ರಿ ಬೇಡ ತಾನೆ. Forthwith ಅಂತ ಹೇಳಿದೆ. Have you seen the act?
I've seen that as an option also.
ಅಲ್ಲ ಅದೇನಾದ್ರು ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ರೆ ನೋಡಿ ಅಪ್ಲಿಕಬಿಲಿಟಿ ಯಾರು ಇವರೆಲ್ಲರೂ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್? Who are they? No, but until, can you take out service by on them personally? Week's time is granted to the needful. In addition, the petitions council is also permitted to take out notice on the unserved respondents personally. Yes. Any promotion is subject to the result.
Yes, now that.
It will be subject to the result of the NN. Whether they intimate or not, they'll be bound by this, isn't it? You made them a party also.
Yes.
Serve them personally first. It's subject result in bada badi. File it along with the memo in the office. Interim order granted, relation continue. Once you put in a spread in memo, seeking to withdraw accepting said memo, it Christian business as well. Service ಆಗಿದೆಯಲ್ಲ? Since gender, age and has entered appearance for respondents want to. There is no need to await for service of notice.
There was, we consider the representation. The Lordship on 6th December on similar note, consider the representation within of living for 2 months.
The covered matter ತಾನೆ ಅದೇ.
No, slow ಮಾಡಿದ್ದಾರೆ. They don't have any instructions. Our matter is not unilaterally consideration. Our matter ಅಂತಂದ್ರೆ I have to take instructions.
I will pass not. I think it's ಅದೇ ಆ ಕೇಸ್. Last day of retirement ತಾನೆ.
ನಾನು ಕೊಡಿ. Representation consider we take accordance with. Some judgment ಇರೋದ್ರಿಂದ we cannot consider.
The prayer made in the state petitions to consider the representation dated 25/5/2023 and annexure D and D1 by which the petitioner petitioner is claiming 1 annual increment for the year of service rendered by the petitioner from 1/4/2010 to 31/3/2011 and consequently fixes basic pay on that basis. It is this case that this increment was denied to him on the ground that he retired on 31/3/2011 and was hence ineligible. Learned counsel for the petitioner submits that this question is no longer. ಅವ್ರು ಹೇಳಿದ ಹೇಳ್ತಿದ್ದೀನಿ. Submits that this petitioner is, this question is no longer presently granted and has been covered by a decision rendered by this court on 13th of September 2023 in WP 11822/2019. In view of the above submissions, it would be appropriate to direct the respondents to consider the representation dated 25/5/2023 and also the decision rendered by this court in the aforementioned petition. So if the petitioner has in fact retired the day after the annual increment fell due, before it fell due, obviously the decision rendered in this court would have to be applied and necessary orders will be passed. This exercise should be undertaken and completed in a period of 2 months. The date of receipt of a copy of this order.
So,
Yes, sir?
serial number 7.
70 December. Dates not mentioned.
Then we consider representation.
Okay, I took that responsibility.
That's the only reason why I objected, not with any.
What is the office objections? Office objection, Naida? What is the prayer? Take out notice on the AGA to take notice for R1 and R3. Who appears from Bangalore University?
Suyogi.
Shri Suyagalde to take notice for R2. Office objection completed and maintained.
The petitioner is an employee of the Russian classification since there is a certificate regulation. Adopted by the government in spite of adaptation by the state, the color judgments are there where the discipline can be only the competent authority to initiate the inquiry. When we say the judgments in Parliament state, after last week, I gave certain judgments.
Kindly refresh me my memory. This was it. Order challenging? You're challenging which order? Next area.
He is a board employee, next year candidate it is issued by the government. Like I come to the reference, the board has obtained after investigation, sent a report, clearly stating that there is no misconduct on part of the petitioner. Next step is the investigation conducted by the senior officer, page 80. He states there is no misconduct on part which is
That is on the merits. The government has decided to entrust the matter to the Lokayuktha under 14A. What do you say it is?
Because 14A it is applicable only to the government servant. 14A.
But what about this rule 35, which makes that
The adaptation is there, let's see, even after adaptation, they gave it where decided where they are exercise 14A. Anything but this is Balarat case. One more case, in another case,
rule 14
is confirmed. It is housing board employee, where CCA which is adopted by the housing board. To lordship take at page 11, para 11, adopted by the board, a AHB, in spite of the relying upon the Indian judgment, doesn't think that they set aside the order of the government.
which paragraph?
Para 11, it is the adaptation, then your lordship may come to.
What are the facts of that case?
The grounds where the initiation itself is challenged, where government issued the 14A order. Lordship may come to para 14, page 52. Condition of the level for the advocacy of the respondent that the decision in Uday level would not applicable decision in general to the facts of the Uday case. That is not clear in respect of the petition of the Revenue Department of decision of Uday. As the government accepted the inquiry to the Lokayuktha, Lokayuktha Act case may be. In Uday case, Division Page 50 note of the definition of public servant under 2G of the 1984 Act, Rule 14 of the CCA rules and relevant CDR rule and arrived at the conclusion that in respect of the employees of the board, since they are not the government servant, basically that the board will obligate to enter the inquiry.
No, this was a case where the Upalokayuktha recommended an inquiry to be entrusted to it. How can you apply the ratio in this decision to this where the government itself took a decision to entrust the matter to Lokayuktha? In the context of that is one thing. In this particular decision, it was the Upalokayuktha who had recommended entrustment of the inquiry to the Lokayuktha under Rule 14A. Government ಮಾಡೋದಲ್ವಾ ಬೇರೆ ಈ ಕೇಸಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಬೇರೆ ಆಗುತ್ತಲ್ವಾ
ಇಲ್ಲ ಈಗ ಗವರ್ನಮೆಂಟ್ page 64. After that, my government sent the file to the board conducted the investigation. Can you see my page 64? And get another fellow, one more judgment I give of the division bench. In this case of the board adopted under the regulation, my district level authority is the board, not the government. Their facts are identical. The 48, 68, that it is applicable only to the government servant. Maybe the provisions of support group shall not contained in the rule 9 to 11A and 13, the applicable for the purpose of proceeding with the government servants whose alleged misconduct has been investigated to be located either under the provisions of the Karnataka Lokaयुcta 1984 or reference from the government. Under even the Lokaयुcta Act also, my lord.
Read the definition of government servant under Rule 2D of the CCA rules.
Means a person who is a member of the civil services of the state or who holds a civil post in connection with the affairs of the state.
What is the meaning of this? Or who hold a civil post in connection with the affairs of the state of Karnataka? You are holding a civil post in relation to the affairs of state of Karnataka. No, you are not a civil servant as defined in the first portion. Means a person who is a member of the civil services. You are not. You are not. Then of the state of Karnataka, or who holds a civil post in connection with the affairs of the state of Karnataka. You are a statutory.
The division bench judgment in the Uddayana's case. Last week, Uddayana's case, division bench judgment after provided. Last week, judgment. Where they distinguish between the civil servant and public servant. I am a public servant. I am not a civil servant.
I am not on that. I am on a different question. There is a two-part definition in Rule 2D. It talks about you holding a civil post under the government. Come back to Rule 2A.
Includes any person who services an employee based.
No, before that.
Means a person who is a member of the civil service of the state of.
Stop there. So that you will not be applicable. Or it's a separate disjunctive word. Or in connection with the affairs of the state of Karnataka.
I am not a civil servant.
You are not a civil servant. You are a person holding a civil post.
I am a public servant. They do is to file a
If you have to apply the CCA rules, to you,
CCA
it-
rules, if we were apply along with this 14A, 14A is only government servant.
government servant is defined under the CCA rules. Correct?
Which
Two,
two D of the local act, two D of the local act.
ಇವಾಗ ನೀವು you are again shifting stance. Under rule 14A, 14A can be applied to government servant. Government servant as defined under the CCA rules defines a person who holds a civil post in connection with the affairs of the state of Karnataka.
That is
There is a difference between,
answer the Mudala's case. So I just make take the Mudala's statement. Last time I could I give one more.
yes,
Still no meaning.
ಕೊಡಿ. ಇದೆ. Which paragraph?
Mudala's and Sannamalappa they answered it.
Which paragraph?
Like Mudala's case.
Where is rule 2D referred to?
That therefore I can show. Page you will have to para 7 alone. Come to para 24 enter rule is third over.
Rule?
Para page 52 para 24. They define what is the computing authority and the 2D of the local
No,
act.
this is, I'm not for a minute concerned about the local act. I'm concerned with the CCA rules which defines what a government. Rule 2D of the CCA rules consider ಮಾಡಿದಾರಾ? ತೋರಿಸಿ ಯಾವ paragraph? I think at page 61, there's a reference. Para?
Para 30 page from 72. This content reading of rule 14A,
Page?
page 72.
Yes.
Content reading of rules 14A with rule 2 interrogatory and 3 of the CCA rule. It is evident that the CCA rules are not applicable to the petitioners in the instance case, although the applies of presidential body or corporation or a government servant, public servant. Therefore, the provisions of PA Act apply to them. They are not government servants within the meaning of 2D, read with 14A of the CCA rules. Thus, even though the provisions of PA Act and PA rules, the competent authority for the employees of constitutive body and corporation of the who are in the case of public servants within the meaning of 212 of the PA Act in the government of Karnataka, but such employees are not government servants within the meaning of 2D and rule 3 of the CCA rules.
No, but the division bench has not considered this expression separately or who hold a civil post in connection with the affairs of the state of Karnataka. That has not been interpreted. You say that does
Rule itself is third out, this
maybe it is called out, but this particular portion is not considered.
Whereas particularly they discuss it and they said we are not government. With reading it 2D with 14A. 14A never says that
Who appears to
public
respond?
public servants.
Who appears? What is your case? After vacation.
Again, one promotion is
ಅವ್ರು ಬರ್ತಾರೆ.
issue ಮಾಡ್ತಾ demand from every act ನಮ್ಗೆ ಏನು opportunity ಎಲ್ಲ ಹೊರ. Therefore, I request.
Understand.
Please.
Hearing ahead, number 34. Initiate.
Yes. What is the order that you are seeking review? What is wrong with this order? Who are you?
I am the grantee in possession of property. I have not been made a party.
No, in this case, what was stated was there's an order passed with the Karnataka Appellate Tribunal in his favor.
The passport and RP was aware that I have been in possession and I am.
Were you a party in the KAT?
No, I'm not in that.
So how can,
I have working behind my back.
so you should challenge the order of the KAT. What is the point in challenging? I don't think there's anything wrong because you are not to be heard in this matter.
Because the property belongs to me and the order is taken behind my back. And after 25 years, they have gone before the KAT and the judge, after 20 years, they have gone before the Tessida. And then now in September 2020.
Are these facts wrong? In paragraph 3, are these facts wrong? Paragraph 3 of the order. Are these facts incorrect? He had said this order of grant, according to the counsel for the petition, was cancelled on the basis of a report of the Assistant Commissioner, which led to the filing of an appeal to the Karnataka Appellate Tribunal, appeal number 444 of 1990. Is it wrong?
It is not wrong.
Then if the KAT has passed an order, kindly appreciate this, if the KAT has passed an order allowing their appeal and setting aside the order of the Assistant Commissioner, then what is the consequence?
Consequence is that the order will be reinstated, the grant will be reinstated.
So therefore, unless you challenge the order of the KAT, what is the point in you challenging this order? This order is only trying to implement the order of the KAT. If that basis is not taken away, this order can't, even if this order is recalled, you will not get any benefit. I don't think there's a ground for review. You should challenge the order passed in KAT by the KAT in appeal number 444/96. That calls for the petitioner after arguing for some time. Seeks leave to withdraw the review petition.
Stay of the order.
No, I will not seeking for sought for permission to withdraw the review petition and seeks liberty to challenge the order passed by the Karnataka Appellate Tribunal, appeal number 444/1996. Since the order which is sought to be reviewed was passed on the basis of the order passed by the KAT in view of the above said submission. Review petition is dismissed, reserving liberty to the petitioner to initiate appropriate proceedings against the order passed by the Karnataka Appellate Tribunal in appeal number 444/1996. In view of the order passed on minutes, there will be no need to consider the application for conditional appeal.
Milords, I appear for the respondents, Milord, in this matter. Milord, we have received the counter affidavit today itself, Milord. We'll serve the copy on the other side. Today itself, we'll serve it, Milord, and a date may fixed immediately after vacation, Milord. We'll go ahead with the argument.
He wants time. He wants a date to be fixed
I'm ready to argue.
after vacation. He is not ready to argue.
Please.
If they are not ready to argue, what is it I can do?
Main prayer, the requisition prayer is different. In this IA, right, only 2 days left. The prayer is entirely different. Only declaration of error. Only absorption of error. It is compulsory. Something that prayer also.
I did the main petition.
Your claim is
Definition of definition of how extra year and so on. Extra year.
you are working under the you are getting the benefit of the 2012 Act after vacation. In matter.
Was in the recommendation made by the RTA to the author that is the LLP department. Secretary.
R3,
R3 Malad.
R4.
Yes.
KPTC MD has made recommendation.
So far as regular outsourced contract by the within produce that annexed UR is interested. Annexed means the second petition 23 people have been terminated in June 2000 after the petition. That's the in fact, I thought is the annexed project allowed. Annexed UR in the first petition. That's the second response. Consider this case.
In a
They
document,
have passed 10 years and now a tender has been given to the private person. He came and checked out 70. I paid an amount. Page 3 of the recommendation letter. The not standing.
document number 1 is what?
The document number 1 is the KPTCL managing director. After the letter to the secretary in the energy department.
No, he's forwarding the representation of the former prime minister. ಉಲ್ಲೇಖಿತ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಹೊರಗುತ್ತಿಗೆ ಕೆಲಸಗಾರರಿಗೆ ಏಜೆನ್ಸಿಯನ್ನು ಹೊರಗಿರಿಸಿ ನೇರವಾಗಿ ಇಲಾಖೆಯಿಂದಲೇ ವೇತನ ಪಾವತಿಸಲು ಕೋರುವ ಮನವಿಯನ್ನು ಬಗ್ಗೆ ಸೂಕ್ತ ನಿರ್ದೇಶನ ನೀಡುವಂತೆ ಕೋರಲಾಗಿದೆ. Is only forwarding the proposal whereby request is made to pay the salary directly.
Constituted by the state based on the Supreme Court judgment. So for that, the welfare measures for the council and contract employees in terms of the contract labor abolition act of 1974. That kindly we take the page 3. Page 3 in page. Third paragraph, last 3 lines. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರೈಟ್ ಸೈಡ್ ಸೆಂಟೆನ್ಸ್ ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತೆಲಂಗಾಣ ಸರ್ಕಾರ ಹೊರಗುತ್ತಿಗೆ ಕೆಲಸಗಳನ್ನು ಪ್ರಾರಂಭಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಮತ್ತು 5/9/2020 ಸರ್ಕಾರಕ್ಕೆ ಪತ್ರ ಬರೆಯಲಾಗಿದೆ. ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತವರು ಹೊರಗುತ್ತಿಗೆ ಕೆಲಸದ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತರು ಈ ವಿಷಯದ ಬಗ್ಗೆ ದಿನಾಂಕ 25/5/2020 ಕಾರ್ಮಿಕ ಇಲಾಖೆಗೆ ಕವಿ ಕನಿಷ್ಠ ವೇತನ ಬ್ಯಾಂಕ್ ಮೂಲಕ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ಮತ್ತು EPF
KDTP.
ವಿವಿಧ ಮಾಸಿಕ ವೇತನ ಹೊರಗಿನ ಏಜೆನ್ಸಿ ಕಾಲಕಾಲಕ್ಕೆ ಬದಲಾಗಿದೆ. ದಿನಾಂಕ 21/2020 ಕವಿ ಲಟೇಂದ್ರ ಸುಮಾರು 8,746 ಹೊರಗುತ್ತಿಗೆ ಕೆಲಸಗಾರರು ನೇರವಾಗಿ ಮಾಸಿಕ ವೇತನ ನಿಗಮದಿಂದಲೇ ಪಾವತಿಸುತ್ತಾರೆ. ಏಜೆನ್ಸಿ ಪಾವತಿ ಸೇವಾ ಶೇಕಡ 5% ಮತ್ತು ಸರ್ಕಾರಕ್ಕೆ 18% ನಿಗಮಕ್ಕೆ ಉಳಿತಾಯವಾಗುತ್ತದೆ. ಸದರಿ ಕೆಲಸಗಾರರು ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ತಮ್ಮ ಸೇವೆಯನ್ನು ಸಹಾಯ
ಕೋರಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಮೊರೆ ಹೋದಲ್ಲಿ ಪ್ರಕರಣಗಳು ದಾಖಲಾಗಿ ವಿವಾದ ಸದರಿ ವಿಷಯ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಅಪೀಲು ಮಾಧ್ಯಮ ತಿಳಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗುವುದು ಸೂಕ್ತವಾಗಿದೆ. ಈ ಮೇಲಿನ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಭಾರತ ಸರ್ಕಾರ ನೇರವಾಗಿ ಇಲಾಖೆ ಸಂಪುಟ ಆಪರೇಷನ್ the bill collector collecting be remitted week management by the computer operator. Now totally another 75 on the computer. May I just take that the page 52 chapter yes. This is the 52 chapter. But this is the Gujarat Electricity Board.
52A is Rajasthan State Road Transport Corporation.
Also, I'm sorry, Rajasthan. Page paragraph 78.
Yes.
So this is not contract regulation. When parting with these matters, they cannot even the undertakings in the contract by engaging a contract, then workman can be applied directly even according to the test based on the only responsible for engaging in contract revenue for the direction has to be monetary advantage by the institution. Apart from the fact that it is unfair, it is also an economically short-sighted and both are the point of view the economic growth is not to be measured only in terms of production. It has to be geared primarily in terms of employment and has to be fulfillment. The attitude adopted by the undertaking is consistent with the need to reduce unemployment and the government policy declared the price to give jobs to the men. This is apart from the mandate of directive of contact of 41, 42, 43, and 47 of the we therefore recommend that all undertakings which are implying the contract in any person or works satisfy the factors mentioned in clause A to B of section 10 should on their own discontinue the contract and observe unfinished labor and feasible as the both the central and the state government should abide the establishment contract labor and based on the basis of contract labor system direction the contract the appropriate government and board should take initiative upon the labor contract establishment procedure. The central government remain act a suitable provision for report to the question of the direct employment the text contract the principal is adopted and the appropriate government represents one aspect. The next statement is full code allotment where the outsourced employees have been directed to the on completion of schedule. That is 2005 the license candidate 188A. All the Supreme Court judgments have been allowed. I won't understand. 188. All the judgments are allowed by the Supreme Court, including this adherence. And the directions have been issued. Page 208.
All of them are prior to Uma Devi.
Yes. In fact, this outsourcement of all these things is contrary to the basis of the humanity. So therefore, now there are two committees constituted by the Karnataka. The contract labor and outsourcing. And government are now as they must be paid the minimum. Even though women reservation after recently issues. But all that I am appealing to the for 10 years, we worked directly with the electricity supply company. Then, in 2021, a tender has been invited, sir, and some of the employees have continued. 23 people have been employed. So that is, the process is done in instance of the government based on this connection. The last time I issue an entry direction, not can dispose it out. If they want to pass adverse order, let them hear me.
No, if there's something to direction to consider, I'll only ask them to consider in the light of the law later on. Apart from that, what is it that I can do?
That's the initial state that is the government.
No, ಒಟ್ಟು 18,000 ಜನ ಇದೇ ತರ your
Reinsertion, you have to act.
No, ಒಟ್ಟು no, according to this letter,
This is pertaining to pay of minimum wages and all that.
Lala, there are 18,000 outsourced employees.
I will learn.
Like ಈ ನಿಮ್ಮ MD letter ಪ್ರಕಾರ
Let it be considered in accordance with law. The government is asking for this judgment for it cannot be. That is recommended for that now everywhere there is. No, recently in power.
if 20,000 people are being employed, virtually 20,000 people are being employed on an outsourced basis, then is this the norm that this is the mode of recruitment from now on? Maybe amend the CN rules to say by outsourcing and then
School going to be the teachers here. No, that's in fact, Nagaperson, Ajay, they said, so for the Morocco, they said, outsource has to be abolished, and wherever 10 years, they must be recovered. Could be limited only to next. Nothing possible. That is letter by MD, connection.
now this letter only forwards a request by the former prime minister to pay the salary directly to you. Apart from that, nothing else is there in this letter.
The regularization.
Yeah. More like comment. ಕೊನೆಯಲ್ಲಿ ಈ ಮೇಲಿನ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ತಮ್ಮ ಆಹ್ವಾನಗಾಗಿ
That you have lordship has cut by submission, you have completed as on today, more than 10 years up to 15 years. Except 23 people who have been kept out during the pendency. Not regular. Interim order is not to the exception, regular.
there's an interim order in your favor.
Out. Harassing case.
I'll permit to give a representation and then let them consider. The prayer, ಎಲ್ಲ petition ಅದೇನಾ? The prayer in these petitions is for issuance of a mandamus to the respondents, including the state government, to consider the case of the petitioners for regularization based on their continuous service in their in their respective establishments of the 5 electricity distribution companies. Next paragraph. Prayers are also made to direct the respondents to pay them equally in terms of Article 39D and Articles 14, 16, and 19 of the Constitution. A prayer is also made to consider their cases in terms of the on par with the outsourced teachers in Moraji Desai schools and extend the benefits of the decision of this court dated 13/7/2012. Lastly, a prayer is made to grant a concession in terms of the government order dated 12/7/2013 in view of Article 371J of the Constitution, and consider the case of the petitioners on par with the decision in accordance with the decision rendered by division bench of this court. Division bench and accordance with the decision of the court bench of this court passed in WP 110831-38/2015. It is the case of the petitioners that the members of its association have been working as outsourced employees, been working as computer operators on an outsourced basis. They contend that they've been working for periods in excess of 10 years and in some cases up to 15 years. And this practice of engaging persons through outsourcing for decades is anathema to Article 14. They also place reliance on judgments of the Supreme Court as well as this court to contend that this practice of recruiting employees on an outsourced basis is violative of the basic norms of justice, and therefore it will be appropriate to consider regularizing these employees. In my view, in regard to the contentions advanced, it would be appropriate to permit the petitioners to make a representation to the government and also to their immediate employers to consider their cases for regularization. They are permitted to place reliance on the judgments rendered by the apex court as well as by this court in this regard. If such representations are made, the state government shall consider the same in the light of the various judicial pronouncements that have been made in this regard and pass appropriate orders within a period of 2 months from the date of receipt of a copy of this order. In brief, 4 months. I can't directly instate this. The second batch of the petitioners in WP 21805/2021 contend that they have also rendered services in excess of 10 years, but their services were discontinued since a fresh contractor was appointed. The petitioners in that petition were also permitted to submit a representation as stated above, and if such a representation is given, the government shall consider the same and pass appropriate orders. Consider the same month. Consider the same.
The petitions, the above petitions are.
Consider the same and pass. ನಾನು ಹೇಳಿದ್ರೆ ಏನು ಮಾಡಲ್ವಲ್ಲ. But this practice, I don't think is. ಆ ಯೂನಿವರ್ಸಿಟಿಯಲ್ಲೂ ಎಲ್ಲಾ ಲೆಕ್ಚರರ್ಸ್ ಗೆಸ್ಟ್ ಫ್ಯಾಕಲ್ಟಿ ಎಲ್ಲರೂ ಹಿಂಗಾದ್ರೆ you represent the agency. You're supporting them or you're opposing them? You're opposing them. In view of the disposal of the above petition, the application filed for impleading would not survive for consideration. Petitioners?
We heard.
How will they consider ಮಾಡ್ಲಿ ಬಿಡಿ first ಆಮೇಲೆ ನೋಡೋಣ. Common matter, what is the last portion is of the penalty. Then I'll allow the application. What are you challenging?
Application and I think the points that we taken up from
After vacation. Vacating stay, no?
the medical people called the final question. As per the medical, I have been appointed and subsequent to the.
What is the stay granted?
Not to recruit.
Not to finalize the selection.
The section and appointment. I forgot one of the posts. Was appointed and thereafter.
What is the benefit of that, this interim order to you?
You know, there is.
No, in what way are you benefited if somebody else is not appointed? No, I will simply say selections will be subject to the result of the writ petition. Neither are you being appointed, nor are you allowing others to be appointed. What benefit will you get? Witness. Who's opposing you? And ready na? Application. What is the prayer? Objections ಹಾಕಿದಿರಾ? Two thousand 12 are pending post after vacation.
Government order.
Next year P na.
Yes, and government order, but only the state was to answer because the.
ಏನ್ covered ಅಂತಾರೆ?
Very same what they were doing is government order.
What was the challenge there?
Medical education hospitals vacancies na health and family welfare ಅದಕ್ಕೆ ಕ್ವಾಶ್ ಮಾಡಿ not to fill up the post because now they are now again they are issued this again they are issued
Witnessed. Post along with W members.
Number 27878. Number 43. Yeah, very short. Very short.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋರು? ಪ್ರೇಯರ್ ಏನು? ಅದೇ ಮೊನ್ನೆ ಲೀಗಲ್ ಪ್ರಾಕ್ಟೀಷನರ್ ತಾನೆ? ಇದೇನು? ಇದೇನು?
Legal practice is a lot of
ಇದೇನ್ ಕೇಸು?
every case is more often than not. One of the best to clean the people where the same other than that, it must be surgery. Exactly. Much
After vacation. After vacation.
It should not have granted on the second. The transfer the loss is second.
What is annexure C?
Annexure C is transfer order. Annexure C. It is passed on 27/10/2023. Not the respondent hearing has taken charge of the office on that day.
Why was he a transfer made in August?
Transfer years, the respondent as well, the register have completed 7 years.
ಇಲ್ಲ ಆಗಿರ್ಲಿ,
Below,
but how can it be done after that date, July?
only 7 years complete.
ಇಲ್ಲ ಇರ್ಬೋದು, but July ಆದ್ಮೇಲೆ ಮಾಡಂಗಿಲ್ಲ ಅಲ್ವಾ? Under the government order is there
The usual way is.
in consonance with the government order only?
Consider, but here, the chairman is the authority. That the,
ಇರ್ಬೋದು, but
they have obtained the chairman permission.
what is the reason for transfer? Because the government order says you should specify the reasons in writing before you transfer.
The transfer rate, 500 meters from Milwaukee, in fourth page of January.
On the-
500 meters. But he has completed 7 years, I have completed 7 years, I have taken charge.
In what way are you prejudiced?
I have taken charge of 30 years.
ಎಲ್ಲದಕ್ಕೂ ನಿಂಗೆ ಬಂದ್ರೆ ಆಮೇಲೆ ನಾನು ಸ್ಟೇ ಕೊಡೋದು ನಿಲ್ಸ್ಬಿಡ್ತೀನಿ. But why are you doing this after that period is over? Tuesday. More to continue. ಚಾರ್ಜ್ ತಗೊಂಡಿದ್ದೇನೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಇನ್ನೇನು? Tuesday. You are? You are accepting the order of the civil court. Last time you told me that you will secure instructions regarding this and then. This petition has been filed challenging the rejection of the claim of the petitioners for payment of family pension. On 29/10/2023, the following order was passed. Pursuant to this order, the civil court has conducted an inquiry and has passed an order on 18th of November 2023 by the said order, the civil court has found that the petitioners are indeed the second and third wife of the deceased Mohammed Qasim Saab. In view of this finding recorded by the civil court that the petitioners are the second and third wife of the deceased Mohammed Qasim Saab, and since the personal law of the deceased Mohammed Qasim Saab permits marriage of more than one spouse, the BPMP would have to necessarily pay the widows, that is the petitioners herein, the family pension that they are entitled to. So this, the ಇಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರಲ್ವಾ? As could be seen from the above, on 29/20/23, this court had directed BESCOM to deposit the entire arrears of family pension before this court, and accordingly, the arrears of family pension has also been deposited. The amount and deposit shall be made over to the petitioners. The BESCOM shall continue to pay them the family pension as per the, you are to pay from which date? Your deposit till September, alva? Shall pay the family pension to the petitioners from 21/9/2023. The petition will be disposed of. ಎಲ್ಲಿ ಮಾಡಿದ್ರ? ಇಲ್ಲೇ ಅಲ್ವಾ? Before this court, I have permitted you to, I have said that it should be made over to you. I have ordered that it should be paid to your clients. ಓದಿ ಮೆಮೊ ಹಾಕ್ಬೇಕು, ಅದೇನೋ ಅರ್ವನ ಎಮೋನ ಕೊಡ್ಬೇಕಲ್ಲ, ಅದ್ ಕೊಡಿ, ಕೊಡ್ತಾರೆ ಆಫೀಸರ್.
Serial number 46, my lords, appear for respondents, my lord. May kindly pass it over, my lord. We are ready to argue.
So, ಬರಲ್ವಾ ಅವರು? ಪಾಸ್ವರ್ಡ್ ಮಾಡೋಣ. You moved the matter and you gave him adjournment. So what is that I can do?
Page number 50. Yeah, Ron Shankar. Yeah, business around what that professor. Not
ಎಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದಾರ? ಮೆಮೊ ಎಲ್ಲ ಹಾಕಿದಾರ? ಇದೇ ಮ್ಯಾಟ್ರಲ್ಲ ಬೇರೆ ಮ್ಯಾಟ್ರ್? ಅಲ್ಲ, ನಾನೇನ್ ಮಾಡಿದ್ದೀನಿ ಆ ಕೇಸಲ್ಲಿ? ನಂಬರ್ ಇದೆಯಾ? ಮಧ್ಯಾಹ್ನ ಕೊಡಿ, ಅದು ನೋಡ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಮಾಡಿ.
petition of 3 years ago, conducted by the
The challenge is seniority list.
Yes. After 11 years, but initially they are at the time of appointment, they were by that seniority and increments are filtered by the appointing authority.
Ready now, madam? I'm ready. What are the facts?
But the petitioner flood. After the ITC, 3 years ago. Certificate was not conducted by the day. Not pursuant to the notification issued by the day, we not defined application. Appointment of not assistant line. That in the year 2005, not they were appointed as line. That at the time after appointment, not the seniority list has been prepared by the day. But thereafter, not the same seniority has been continued till 2015. And even at the time of not giving him not a promotion as a lineman, not the same seniority has been continued. For the first time in the year 2015, while considering the case of the petitioner from the mechanic grade 2, that the seniority has been entirely turned. And the respondent were respondent number 4 to 21, 5 to 21, the were put in seniority list above the petition.
They were appointed before you or after you?
Both women petitioners as well as these respondents are appointed in the same time, in under the same notification. They, but the seniority list was prepared at the time of appointment. But these respondents are junior in the seniority.
Then why were they placed above? What is the reason for placing them
Reason
above?
assigning that fact, at the time of, there is no reason assigned. The what they say is madam, at now the seniority is the for the first time is based on the marks obtained in the certificate. But these the petitioners are obtaining ITC. This is the training institute run by the KEB 3 years ago. But they respond to not ITC. It is a 2 years diploma.
That is their objection?
Yes. They are admitted in their objection that.
Where's the endorsement? Page?
Page 19 of my application. It's filed on 11th April, the
Read that. That is what they have challenged, isn't it? No, but they are challenging the seniority list, saying that the seniority list is correct. So why should they challenge this?
RMC regulations are applicable to visitors as per 5A and B of the regulations.
Please show, where is that regulation? Where is the order of appointment?
Yeah.
Next year? ಒಬ್ಬೊಬ್ಬರದೇ ಇದೆ ಎಲ್ಲ ಒಂದೇ ದಿನನಾ? Which do you want me to read, madam?
Page 200.
Ah.
A and but the decision regarding the seniority of direct shall be made by appointing authority at the time of their first appointment in the following manner. A, when the recruitment is made on the result of completed exams for the test, the order of seniority to be in order of merits.
This was not on the basis of a competitive examination. So,
Petitioner for IT, 3 years ago.
And then made by section, the order of senior is given as the order on which the candidates are written in order of merits by the authority making the selection.
where is the list that is prepared? Where is the order of seniority?
Yes, my presentation is placed as para 3 of my objection. I want to raise it. Para 3 of that. Para 2 on the case. It is on para 2. It is indicated that the response are gone by the Karnataka elections board of the relation shall define in the relation. Place of an employee in order to ranking in the particular grade and resolution 5 provides as follows. A decision regarding the seniority of direct shall be made by the appointment at the time of appointment. Conception that is made on the result of the competition for the order of seniority in order of merits. It is submitted that the present appointment is in respect of petition and the exam of file of petition will fall under the regulation 5E. And the seniority would be determined in order on which the candidates are arranged in the order of merit by appointed authority or other authority within the petition. In the instant case, the petition has completed their ITC code and are selected for the post of assistant lineman. Whereas the response for 5-21 has been completed ITI and has been appointed as the assistant lineman. The ITC course is conducted by the CH-16, whereas the ITI course is conducted by the colleges and institutions. But however, since the eligibility criteria has been prescribed in ITC and ITI and OJT, the petitioner and the respondent have been applied and the selection for the post of assistant lineman. At the relevant point of time, the seniority is prepared by the appointed authority in the order of merit. The group of the said merit is the future.
No, they were appointed as what? They were appointed initially as assistant linemen. The rule 5B which you rely upon says
And the
to be determined by the order in which the candidates are arranged in the order of merit. Where is that arrangement of the candidates in the order of merit? All of them are above them. Respondents, where are they? Where are the petitioners?
Initial files in agreement.
La seniority list pada. According to this regulation, in the order of merit arranged at the time of your appointment.
You should find that.
Are you below?
Yeah.
Are you below them or above them in this order of arrangement?
In the 2005, we are above the response.
Seniority list pada. When you were appointed initially, the rule says shall be determined by the order in which the candidates are arranged in the order of merit. So when you were appointed, according to them,
Certificate course, that there are 2 certificates.
No.
ITC is 3 years.
in the select list that was prepared,
Yes.
are you above them or below them?
We are above this.
Where show me from annexure R1.
Yeah.
Annexure R1 torso. Annexure R1 is this arrangement of candidates in the order of merit according to them. In this, if you are above them, then automatically you will be senior.
page 16, stone shaker assignment. Page 16. Item number
What about the respondents?
9. 43 is the stone shaker assignment, 49 is the Australia.
Now, where is this? Over the page number?
Not appointment list. Senior list alternation. Yep. Seva is another. I am not Seva is another. But more.
Yeah, got a page number? Page number?
The other petition is at page 18.
First petitioner?
Then it is page 16. Page 16, item number 15.
What about the respondents? ಇಲ್ಲಿ ತೋರಿಸ್ಬೇಕಲ್ಲ. Now, this is only the list of candidates. Where is the arrangement in terms of senior, the order of merit? This is only an enclosure of the list of selected candidates. No, this is a communication to the superintendent engineer. I am enclosing here with the list of selected candidates of assistant linemen for your reference and needful action. As per R&P regulations, you are empowered to issue the appointment orders to the assistant lineman post against the existing vacancies. While issuing the appointment order, you are instructed to follow the quota rule and other existing rules and regulations in order to maintain roster cycle. Please note that the appointment order and other connected lists are likely to be verified with the Department of Government of Karnataka. Really concerned with the reservation. Where is the order of merit that you indicated? You have sent list to the superintendent engineer of Mysore and Asal Circle. What is there to show that this is the order of merit that is contemplated in that rule 5B? This covering letter does not indicate it. If they had said the following candidates are appointed in the following order of merit, then yes, this is only enclosure of a list of selected candidates. If you have not followed 5B, how can you rely upon this list of selected candidates to say that this is the order of merit? And if you have indicated that seniority in your list differently,
The list of prepared transfer and the candidate based on IPP and IPS based on the seniority specified in accordance with the permission having granted to the respondent of 5
whether they have ITC or ITA, that is no consideration according to 5B, because it's in the recruitment is made by selection. The order of seniority will be determined by the order in which the candidates are arranged in the order of merit by the appointing authority. Where is this arrangement in the order of merit by the appointing authority?
In the appointment order, you are instructed to follow the data.
That is regarding reservation. Regarding the order of merit, where is the finding? Because if the order of merit is not indicated under Rule 5B, and you have given seniority for a period of time under the seniority list, which was not objected to by them, how can you change it?
There was a direct dispute by the authority saying that the seniority should be in accordance with the seniority given by the appointing authority. So when passing this the order for the first time in the year 2015, the officer not is only in charge also. So pass the to change the
How many times was seniority is published between 2005 to 2015?
Once in 2 years.
Then
Once it is up to.
how can you rearrange seniority if 10 years after they were recruited? Or private respondents yaru bandilva?
They already got the second promotion. Mechanic grade 2 is the grade 1 year. They are already promoted.
Even now they are not objecting to this writ petition. Wednesday. Wednesday.
This is the matter of year 2016.
Wednesday. Ready? What is the challenge here? What is the next year V? Next year V challenge ಮಾಡಿದ್ರಲ್ವಾ? So according to them, we do not have both 18 years experience, that 18 years and
That are the situation. And but the circular actually that
this page 145 clause 2, as envisaged in the pay commission implementation orders, it was also decided that the minimum cumulative service rendered by an ADA employee for elevation from grade pay to 2400 to 5400 will be 18 years with minimum 3 years in grade pay 4600. That is the reason.
This that are the PPTs. But if we said we are pretty guidance. These are the different state approach is that we did not follow pretty guidelines. We have adopted the changes. As a part of the posted the documents we just before as to how the people for the 18 years of service, military service. That includes towards all the degrees of they said, no, we have considered the provision ad hoc only that
they will also be ended for the past, for counting the past service. Why not?
The petitioner was entered in 2000. When 18 years, there occurs in the great way of 4060, 30 years, then he is eligible for great way of 5,000. He joined in 2012. So he is promoted in 2020 and as
How did he join?
he was previously in a different organization. He resigned and he came to.
The appointment was through the proper channel, isn't it? The appointment was sought for through the proper channel. So he will not lose his earlier service. If he had been appointed afresh, what you say is correct. But if he had been appointed by you, when his application came through the proper channel, after he had given a technical resignation there, how can you deny him that service? If you take the service that he had worked rendered in Air Force, would he not satisfy that condition? When he entered IAF, he was in a grade pay of 2400, isn't it? You're now ignoring the service that he rendered in IAF and you're considering the service rendered only under ADA. And because that amendment was made, that 18 is also you're foregoing now. And you promoted me the moment the amendment was made.
He was so that
Can you go against the DOPT circular? So you can also ignore the rule if he wants, according to you.
So that automatically in 2000, was also he wants from 2000.
Where is that circular where you adopted? Next year?
This is what 2000.
Which required 3 years plus 18 years. Please read that. Page 135. Alva?
Object to the R46 CPC case in ADA from 1 2006. There is a need for amending the recruitment motion policy in ADA corresponding to the revised pay tax, claiming and sensitive reduced by revised pay tax. The amendment of recruitment motion policy as per the revised state of the DOPT letters also dated solution and DRDO letter dated also has been taken up and the revised recruitment rules and policy area will be finalized shortly. Meanwhile, such of those employees in the unified cadre of the secretary cadre, you will have completed 3 years service in the post of technical finance, commercial, executive staff officer in BB2 with the gateway of the post of with a minimum cumulative service of 18 years from the date of appointment in the post of the assistant stenographer in the ADA in the scale of rupees so in PB1 are being considered eligible for assessment to the next year post. In PB2, the rate of 5,000 per day. Candidates for completing the qualified service as only depends.
This was pending amendment of the recruitment rules and promotion policy. This particular para 2.
This was addition we are making.
No. This was pending amendment to the recruitment rules and.
I have put it around the communication.
No. If you read the first paragraph, once again, last 3 lines. The amendment of recruitment rules and promotion policy as per the guidelines laid down by Government of India DOPT letter number so and so and DRDO letter dated so and so has been taken up and the revised recruitment rules and promotion policy of ADA will be finalized shortly. Meanwhile, so this is pending amendment of the rules. What was the ultimate amendment to the rules? Where is the rules amended? Where is the amended rules? The amended rules also are the same, to the same effect?
There are cases that are very rich. Versus petition, you know what was finding was classification. It's a.
What is this memo?
No, the things.
No, all this is ultimately, the culmination is circular dated 11.
They say, so it's practiced as per the DOP guidelines.
Correct. So it also says first paragraph saying that they're amending the recruitment and promotion policy.
It is subject to.
What is the recruitment policy amended?
Because, even going by this say, the proposal is different, so that two would be compliant with the DOP guidelines.
You are claiming DOPT guidelines dated, which is the date?
It was March 2009. Yeah, right. But so that, she was addressed by the grievance committee. They say the DOPT guidelines is applicable. Lots of states not.
But he's saying it can be postponed because this particular first paragraph also accepts the fact that you are following the DOPT guidelines. So where do you say you can modify? The note sheet does not determine, circular is what is important, isn't it? Several things are made in the note sheets. But ultimately, what is a circular? That you are following the DOPT dated 24/3/2009. If 24/3/2009 simply talks about 18 years of cumulative service.
It speaks of only 5 years, 3 years responsibility.
Then you're adding this additional 18 years. How can you do that?
Being an anonymous better take one case.
Does the DOPT permit you to do that? This 24/3/2009, does it permit you to add or subtract conditions?
So I
Where is that DOPT circular?
circular is 11/12.
No. This 24/3/2009, you produced it. Shrikant, you produced it 24/3/2009.
Okay, but they are think towards connection AC. Into the 126 towards the grievance towards the grievance. There they reply. And they say towards the stating of the instruction number 46. 156, next page, page 2. Point of first for 6. The background of promotion transfer measure of incidents of promotion QP was necessitated the duty in the ADA that the 16 the source had approved the appropriate training and the changing the results for promotion of all administrative and supporting staff the technical social resource sections in line with they say it is in line with the development plan, but it is not intercompatible with the development plan. How can they say not something different?
So this is the amendment that you have made as per this clause 6. Has approved an amendment to the ADA recruitment and promotion rules 1990 by changing the residency period for promotion of all administrative and supporting staff from grade pay 4600 to 5400 from existing 5 years to 3 years. This is the only requirement according to the recruitment rules. No, according to your recruitment rules. It only reiterates whatever is said in the circular. It does not talk about recruitment, but para 6 talks about recruitment. That is what is mentioned in clause 6, not it?
Class.
Suppose in the recruitment rules, this period of 18 years, cumulative service is not found. Then this will have to be applied, not the 18 rules, 18 years.
I replace the.
But read the recruitment rules. Then 1990 ಹೇಳ್ತಾರಲ್ಲ. ADA recruitment and promotion rules 1990. Which as amended on 21/6/2012. Produce the amendment to that ADA recruitment rules as indicated in paragraph 6.
18 minutes.
ಆಮೇಲೆ 2009 ಆದ್ಮೇಲೆ.
2012. I replace it.
Which is that rule on the basis of which you,
But what I say is that the issue was taken up for the previous side. They say we have in terms of the in line with the.
where are the rules? See, that is only a circular. If the rules permit only 3 years of that requirement of 3 years in that particular grade pay, then the reliance on the second paragraph.
The rules are paid. Then we have 90 years. Mission is put as that the contention that we think that are not correct. Because
Suppose the rule stipulates that if there's no challenge to that rule by you, I can't ask them to go against the rules, isn't it? Suppose the rule is amended indicating both the requirements and if that rule is not challenged, how can I ask them to implement that rule? If the rule only talks about 3 years, then the second portion of circular becomes bad because that is only an interim arrangement.
the circular says cumulative service.
No, if the intent of para 2 of the circular is not incorporated in the rules, then it's only an interim arrangement. Used.
Government inquiry committee has also been in the effect of very safe master of selection, transmitted a committee. That has been challenged with the selected candidate. Second, system is represented for that matter. Looking to regarding, you have been promoted to that.
In my case, there's no.
My expectation
No,
is.
sorry, that's just fine.
My expectation may be, the reason is.
Second.
Government has constituted a committee to inquire as to whether there is irregularity in personnel and appointment. Where the order of the government is under challenge, I think. No fundamental right is violated to the division is challenging constitution of the committee. No inquiry has been done as on today because of the issue of this. So insofar as the validity of the constitution of the committee, also we believe that it is.
What is your case? What? Same, which under which they are selected. On what ground?
That is the complaint made before the government the.
No. What is your ground of attack? Why should they not be appointed?
They have been allowed.
You were also a participant in that. Then
I have been for the process of the appointment which has been challenged. In my process, where this marks has been assigned to me, it's a mistake in the total mistake.
what are you challenging now?
Process of the appointment which has the other.
No, how are you aggrieved by their selection?
Where I am assistant.
So you're already in the post. Then how are you agreed by a subsequent recruitment?
But based on the inquiry report, you said the inquiry should be based on the inquiry.
No, Badri, you were appointed when?
They are appointed, they are working as each other candidate, they submitted their application. They are not being selected. Therefore.
So you are also an applicant under the same notification. You are also challenging selection on the ground that the marks allotted to you is incorrect. And you are challenging the Then why did you make an application for assistant professor post?
All the petitioners that government. They are all.
I am dealing with Badrinath's writ petition.
Challenges not the entire thing on the same place.
No, first paragraph you say you are aggrieved by the non-selection to the post of associate professor. ನೀವು ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀರಾ ಅಲ್ಲಿ? As what? You are an in-service candidate. Then objections ಹಾಕಿದ್ದಾರೆ ನೀವು?
Consider approval here. The people their position is next they are going to promote it as an associate professor. It can be over as well as not before. But the inquiry is
Out of-
for the government.
ನೀವು objections ಹಾಕಿದ್ದೀರಾ? After vacation.
Your Lordship. Serial number 55, Lordship.
Yes.
Honor, Your Lordship. Senior will traveling from Dharwad to Bangalore, Your Lordship. We can take on Monday. Senior will physically appear in Monday, Your Lordship.
Please, sir.
What is the matter about?
But the petitioner could not have cleared up. Correspondence. Petitioner could not have challenging. Provident is not the process granted to the.
Objections ಹಾಕಿದ್ದೀರಾ? Where is Sanjeev? Expert. Witnessed. Date ಕೊಡ್ತಾರೆ. Next week date ಕೊಡ್ತಾರೆ.
ಜಾಸ್ತಿನೇ ಇದೆ.
ನೋಡ್ತಾರೆ ಅಂತ ಟ್ರೈ ಮಾಡ್ತಾರೆ ಯಾಕಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಜಾಸ್ತಿ ಇದೆಯಂತೆ. 58 ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ನಿಮ್ದು ಎಷ್ಟೇ ಮ್ಯಾಟ್ರ್ ನಿಮ್ದು Who's opposing you? Since it is submitted that in the connected matters, there is an interim order in operation. It would also be appropriate to grant an interim order as prayed for in this writ petition. Extend matter. No, let us come.
Court officer?
Environment ಕಳಿಸ್ಲಾ?
Court officer.
Wait ಮಾಡಿ ಕಳಿಸ್ತೀನಿ.
No data.
Court officer.
ಹೇಳಿ ಹೇಳಿ
Serial number 19 ಏನಾದ್ರು ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ ಸರ್?
19
ಹಾ
19
sorry 18 WP 33099 of 17 serial number 18.
18 after vacation.
Okay, thank you.